Hello, this is R.J. Deacon reading the Supreme Court of the United States opinion syllabus in United States Patent and Trademark Office versus Booking.com. Certiorari to the United States Court of Appeals for the Fourth Circuit. Argued May 4th, 2020. Decided June 30th, 2020. A generic name, the name of a class of products or services, is ineligible for federal trademark registration. Respondent Booking.com, an enterprise that maintains a travel reservation website by the same name, sought federal registration of marks, including the term Booking.com. Concluding that Booking.com is a generic name for online hotel reservation services, the U.S. Patent and Trademark Office, PTO, refused registration. Booking.com sought judicial review, and the district court determined that Booking.com, unlike the term booking standing alone, is not generic. The Court of Appeals affirmed, finding no error in the district court's assessment of how the consumers perceive the term Booking.com. The appellate court also rejected the PTO's contention that, as a rule, combining a generic term like booking with .com yields a generic composite. The Supreme Court held the decision below is affirmed, and Justice Ginsburg delivered the opinion of the court. A term styled generic.com is a generic name for a class of goods or services only if the term has that meaning to consumers. Whether a compound term is generic turns on whether that term, taken as a whole, signifies to consumers a class of goods or services. The courts below determined, and the PTO no longer disputes, that consumers do not in fact perceive the term Booking.com that way. Because Booking.com is not a generic name to consumers, it is not generic. Opposing that determination, the PTO urges a nearly per se rule. When a generic term is combined with a generic internet domain name suffix like .com, the resulting combination is generic. The rule the PTO proffers is not borne out by the PTO's own past practice and lacks support in trademark law or policy. The PTO's proposed rule does not follow from Goodyear India's Rubber Glove Manufacturing Corporation versus Goodyear Rubber Corporation. Goodyear, the PTO maintains, established that adding a generic corporate designation like company to a generic term does not confer trademark eligibility. According to the PTO, adding the .com to a generic term like adding company can convey no source identifying meaning. That premise is faulty, for only one entity can occupy a particular internet domain name at a time, so a generic .com term could convey to consumers an association with a particular website. Moreover, an unyielding legal rule that entirely disregards consumer perception is incompatible with a bedrock principle of the Lanham Act. The generic or non-generic character of a particular term depends on its meaning to consumers, i.e., do consumers in fact perceive the term as the name of a class or, instead, as a term capable of distinguishing among members of the class? The PTO's policy concerns do not support a categorical rule against registration of the generic .com terms. The PTO asserts that trademark protection for Booking.com would give the mark owner undue control over similar language that others should remain free to use. That concern attends any descriptive mark. Guarding against the anti-competitive effects the PTO identifies, several doctrines ensure that registration of Booking.com would not yield its holder a monopoly on the term booking. The PTO also doubts that owners of generic .com brands need a trademark protection in addition to existing competitive advantages. Such advantages, however, do not inevitably disqualify a mark from federal registration. Finally, the PTO urges that Booking.com could seek remedies outside trademark law, but there is no basis to deny Booking.com the same benefits Congress accorded other marks qualifying as non-generic. The decision below is affirmed. Justice Ginsburg delivered the opinion of the court, in which Chief Justice Roberts and Justices Thomas, Alito, Sotomayor, Kagan, Gorsuch, and Kavanaugh joined. Justice Sotomayor filed a concurring opinion. Justice Breyer filed a dissenting opinion. Thank you for listening. If you'd like to get a hold of the podcast, I can be reached at rhodesscholar80@gmail.com. That's ROADS and the number 80.